The Journal Editorial Report. Analysis and opinion from the editorial board of the Wall Street Journal. This week, the White House struggles. The president's Supreme Court nominee withdraws in the face of widespread opposition. What are the lessons for the administration? Another crisis avoided. No indictment against the president's top advisor, Karl Rove, in connection with the leak of a CIA officer's identity. Can the president move on? And Tony or tacky? Is there more to this than the final score? Exclusive corporate funding for the Journal Editorial Report is provided by Shell.
Sam Singh is captain of a Shell liquefied natural gas carrier. Every year, ships like Sam's carry 9 million tons of this clean fossil fuel.
You chill it to minus 160 degrees Celsius, it shrinks. You stick it in here, and then you go for a sail.
Today, it's our mission at Shell to connect the world's gas markets like no one else. Our mission, and Sam's.
Funding also is provided by the Corporation for Public Broadcasting. Now from our studio in New York, here is the editor of the Wall Street Journal editorial page, Paul Gigot.
Welcome to the Journal Editorial Report. It could have been worse. President Bush had to accept a punishing defeat on his nomination of Harriet Miers for the Supreme Court. But the feared indictment against his top advisor, Karl Rove, did not come down. First, the Miers case. She withdrew when it became clear she was not making headway against the opposition to her nomination from all sides, especially from conservatives. Now the president faces some critical decisions on what to do next. Joining me to discuss this are Dan Henninger, columnist and deputy editor of the Wall Street Journal editorial pages, David Rivkin, an attorney who has served in the Justice Department under President Reagan and the first President Bush, and who has written for the Wall Street Journal, and John Fund of OpinionJournal.com, who, on this program last week, predicted the Miers nomination was going to end this way. John, the president has another nomination to make, obviously. What are the lessons for him as he thinks about that pick from this failed nomination?
Paul, I think there are three lessons. One is, no matter how well a president knows someone that he wants to appoint to high office, he has to go through a proper vetting process and ask them the tough questions. That wasn't done with Harriet Miers. Secondly, the conservative base in this country, I think the White House often misunderstood their loyalty to President Bush as being loyal to him only. They're actually loyal to a set of ideas. The White House thought the conservative base should follow the dictum, our leader, right or left.
Yeah, but, you know, the conservatives, and certainly our page, has long believed that presidents deserve deference when it comes to Supreme Court selections and major nominations for that matter. Why didn't the conservatives, who are his natural supporters after all, give him that deference in this case, Dan?
I think largely because they were so shocked. As we said before, the Supreme Court nomination process as an issue dates back to the Bork nomination. The Bork thing is just this sort of legendary event in conservative lore. And it is not just an incident in history. It happened way back then. After it happened, the conservative legal community banded together and decided they would develop a theory of law, a bench, a whole generation of respectable, intellectually respectable legal theorists and judges who would not, you know, the Democrats and the liberals would not be able to Bork, in effect. And so when President Bush essentially stepped off this 10 to 15 year process, and as though it had not even happened, it was intolerable. It was just too shocking to the system.
There's another fundamental reason. This is such a consequential decision. We've talked about it actually in this program some weeks ago. Because if you think about it, every issue of importance in public policy, of foreign policy, has been swept into the judicial vortex. But it's very ironic. Democrats have built, over a period of decades, the courts into those centers of power and made it so consequential. If you prune the judicial function to its constitutional essentials, frankly, it would not be that much at stake here.
Well, also, you wouldn't have the confirmation battles we have now, which are basically like battles for the Senate. I mean, you have every interest group using commercials.
That's right.
That didn't happen when the court limited its role to what the founders intended.
David, several people I respect, including one of our colleagues, George Malone, argue that this withdrawal by Harriet Miers is a blow to the president, and because it's a blow to his prestige and his authority in Washington, and it means that it's going to be open season on him from all kinds of sources to people say, look, he can be ruled. Do you agree with that?
No, I don't. In politics, being able to realize that a mistake was made and correcting it early, and it was reasonably early, to me is a virtue, not a vice. Second, I think events that you've described in the introduction are going to move in a direction where this will be overtaken in the next several days. Point number two, the base is very anxious to put it behind him, and frankly, it's going to be a tough fight on the next conservative nominee, and I think it's going to, again, unify.
In 1987, Ronald Reagan nominated Douglas Ginsburg to the Supreme Court. He had to drop out because of alleged marijuana use. Within 5 weeks, the president had nominated Anthony Kennedy, who had a track record as a conservative judge, and he was approved unanimously. It can happen. Is
there a lesson here for the president about how deferential to be to the Senate? Because he's made a real point about talking about consultation, and there's no question when you talk to some White House sources that they'll tell you that, 2 or 3 of the names that we had thought might be nominated, and some of the people in that farm team you talked about, Dan, were off the table because senators said, sorry, too heavy a lift, too controversial. Should he pay attention to the Senate?
I think that's one of the great ironies here. The conservatives, the conservative legal community, and expands beyond them as well, they want to have this debate in front of the Senate. They want the national television cameras turned on this nominee, and they want that nominee to defend these ideas. The political side, and that includes the White House, doesn't want to have that debate. Nor do the senators very much want to have that. The Democrats do not want to make a good faith effort to engage these people. They simply want to find out their position on Roe v. Wade.
Well, wait a minute here. I mean, John Roberts did not have that long a track record. Certainly didn't have a Borkian paper trail. And yet he was shown a great deal of respect and deference by the conservative interest groups and by conservative senators. What's the difference between John Roberts and Harriet Miers?
Well, I think what you have here is the administration really believed that Harriet Miers would be a super stealth nominee. It turned out that she could not name anyone that she had ever had a conversation with about serious philosophy or judicial intent. As a result, John Roberts had 30 years of impressing people that he was a person of ideas. Quality matters. Harriet Miers couldn't demonstrate that she would clear that bar.
Yeah, I think that's a very important point. Quality matters. People understood John Roberts they knew him from Washington, and everybody, even Chuck Schumer, was obliged to say, look, he's a brilliant fellow. That makes it much harder to defeat somebody when it goes to the Senate.
And we know one simple proposition, that if you come in without strong intellectual grounding, you tend to drift to the left. Because so much of the pull of popular culture, the salons of Georgetown, being praised in the New York Times.
What do you mean if you come onto the Supreme Court?
Right. So you almost have to be super armored with well-developed, well-crafted judicial ideology, and even then it would be tough.
Dan, let's talk about the next nomination, because the conventional wisdom in Washington is now that the president has this narrow margin because he's got to thread the needle between the conservatives who he needs to get back, but he can't go too far to that direction because he doesn't want to pick a big fight with the liberals. You agree with that wisdom, so-called?
Well, I think, yeah, up to a point. I think it's a bit of a non-issue because there's a list of at least 15 or 20 nominees as a result of the process I was describing earlier that's taken place the last 15 years who would be perfectly capable. And if he wants to go from, extreme conservative fire-breathing but highly intellectual over to someone in the right, but nonetheless a member of this intellectual community, he can find that person. It's not going to be hard.
Can he get the conservatives back supporting his next nominee, David?
Short answer is yes. They're very eager to go.
And how does he do that?
He appoints a person who is conspicuously within that stream that philosophy described, original intent, similar to Scalia. That is, again, not a fight about overturning Roe versus Wade. This is a fight about the role of the judiciary in a democratic society like ours in the 21st century.
We can't leave this discussion, though, without describing the possibility of going to the nuclear option. if the Democrats decide they're simple. And, you know, they were going to oppose Harriet Miers because they convinced themselves that she was going to overturn Roe v. Wade. If they convinced themselves about the next nominee, we're probably heading down the road to a filibuster and the nuclear option.
So what you're saying is that the fight over the next nominee would actually help the president, be useful for him. He ought to do it. He ought to welcome it because it would rally his support and be over something that matters.
It's one of those rare things, Paul, where they have the imperatives of good, sound policy and good politics are the same.
So do you think he names a conservative nominee?
I think he's going to name a
Who do you think it'll be?
I would predict Alito.
Sam Alito.
Sam Alito,
a judge on
the Third Circuit.
Who Specter likes a great deal, the Judiciary Committee Chairman.
Arlen Specter likes. How about you, Dan?
Well, I wrote a week ago, withdraw Harriet, nominate Edith Jones of the Fifth Circuit in New Orleans. I'm going to stick with it.
John?
Chris Cox, the new head of the Securities and Exchange Commission, has just been vetted and confirmed unanimously by the Senate. He's a very powerful lawyer and was in the House leadership and knows half the Senate personally.
J. Harvey Wilkinson would be my pick. Fourth Circuit, I think, is here.
And Chief Judge of the Fourth Circuit.
Okay. All right. Thank you all very much. Next subject. On the other big story of the week, the news was not good, but not disastrous for the president. Special counsel Patrick Fitzgerald decided not to seek an indictment of the president's top aide, Karl Rove, in connection with the leak of a CIA officer's identity. True, a 5-count indictment did come down against Vice President Cheney's chief of staff, Louis Scooter Libby, charging him with lying and obstructing justice. Libby resigned, but that was not the political blow an indictment of Rove would have been. Joining us to discuss this story is James Taranto, the editor of OpinionJournal.com. David, before we get to the politics of this, let's talk about the merits of this particular indictment. 5 counts, false statements, perjury, obstruction, serious charges. As you look at the merits, how solid is this indictment?
Serious counts, to be sure. Perjury and obstruction are not to be taken lightly. But the facts are, there's his version of events, Libby's versus the version of events of other people. It was more in the nature of he said, somebody else said something else. But far more fundamental to me, what the indictments do not contain. Remember, this whole matter was referred to Fitzgerald because of speculation that there was a violation of Intelligence Identity Protection Act 82 statute, very important.
1982 statute.
1982 statute, very narrow statute that prohibited leaking of information of covert operatives, very small portion of the CIA employees. No allegation that in the indictment, no charges that was done. Interestingly enough, the indictment mentions the possibility that Belly Plame's name was not known outside of the intelligence community. There's a little bit of a smoke there, but no indications and no charges of violations of classified information under the Espionage Act.
So, an allegation here of lying about a non-crime.
That's right. There is, from what we see in this indictment, we see no evidence that any crime was committed before Patrick Fitzgerald took on this case, even if Libby is guilty of everything he's charged with.
That's astonishing. It means that the whole beginning of this scandal and all of this, there really was no fundamental violation at the heart of it.
It's a Seinfeld scandal. It's an investigation about nothing.
Right. Well, it began as an argument over the yellow cake stories out of Niger and so forth, and whether that was a basis for going to war in Iraq, and that in turn got built into a political dispute between the White House and its opponents. And I thought Patrick and that leaked over into the, so to speak, into this Covert Intelligence Act. I thought Patrick Fitzgerald put it very well when he analogized it to a beanball in baseball. The reason pitchers throw at guys' heads in baseball is because they're getting back for something the other team did. It's like the code of the game. It's like when hockey players knock each other down. And what Fitzgerald was saying, I'm not going to pass judgment on this street fight you guys are having over politics here. I'm just looking at what happened in terms of obstruction and perjury. He refused to touch the political side of this issue.
On that point, we have a soundbite from Patrick Fitzgerald where he makes his case of why this is serious. Let's go with that.
If the charges are proven, remember there's a presumption of innocence, but if it is proven that the chief of staff of the vice president went before a federal grand jury and lied under oath repeatedly and fabricated a story about how he learned this information, how he passed it on, and we prove obstruction of justice, perjury, and false statements to the FBI, that is a very, very serious matter.
How do you respond to that, David?
Respond to it this way. It is my theory that Mr. Fitzgerald knew within a few weeks of taking on his charge, that no violations of the Act, violations of which Intelligence Identity Protection Act possessed and
the leaking charge.
The leaking charge were true. And the reason for it, if you look at his initial letter, which you received from Mr. Comey, dated December 30th, it only mentions that statute. By February 4th, there's a broad letter giving him plenary power to investigate everything. My question to him is, if he knew by early January or mid-January that no violations of that statute occurred, why would he not bring an investigation to an end? Why would he continue to investigate, put people before the grand jury, put reporters in jail, and if he will create almost an ambiance where those types of things arose?
Well, I think the answer to that is he's a special prosecutor. Right. He had a mandate to investigate this to whatever extent possible. He was granted extraordinary powers. And you have to fault the Bush administration for allowing that to happen. It's the same sort of hubris that President Clinton displayed when early in his term he signed the reauthorization of the independent counsel statute, which has since expired, on the grounds that, well, we're not in any danger, we're the most ethical administration in history.
You're right. The problem is, to be fair, though, the independent counsel statute and special counsel procedures predate the Bush administration. There's a whole ethos in a post-Watergate environment, which says if you're a senior government official, we're going to take you out of a normal justice system where prosecutors operate subject to all the normal bureaucratic checks and balances. And very important one, having other people second-guess you, because none of us is that smart. Special counsels are loners. Nobody second-guess them. A limited resource has limited time. You can take the most honorable person, if Fitzgerald is very honorable, put him in that position, and it skews, it warps your judgment. And this is an instance just like campaign finance reform, that the cure is worse than the disease.
Well, you make that point, and I happen to agree with it, but the problem is, James is still right, it seems to me, about the Bush administration, because John Ashcroft recused himself from this case, leaving the decision to supervise Fitzgerald in the hands of the Deputy Attorney General, James Comey, who was his old friend from the U.S. Attorney's days. And that seems to me to have been a political abdication. And the president let it happen. So, in a sense, he's the man who fired the torpedo that has now hit the hull of his administration in the second term. He has to be responsible.
You're right, Paul, but my only point would be that the nature of politics and bureaucratic organizations, if you have a bad system that allows people like Comey, like Ashcroft, to escape political responsibility by passing the buck, chances are very high that they'll pass the buck. It doesn't vitiate individual responsibility, but let's be mindful that it's a problem of the system, of the rules.
I want to ask something about motive here, because there's one thing that is missing in this indictment as I read it, and that is why Scooter Libby would have lied to the grand jury if, in fact, he was not covering up a crime in the first place. As we know, he was not charged with that crime. So what is the motive here for him having lied about about how much he knew about James Wilson's wife, Joe Wilson's wife?
I can't begin to guess, Paul. I mean, to me, one of the most fascinating aspects of this is what it says about the substance and content of the way the newspaper business is done and the way politics is conducted in Washington. These conversations took place at least 2 years ago. Reporters and public officials talk to each other constantly all day long. Libby has been indicted for 3 conversations. He probably had 300 conversations in that time period. And people are talking about, they are indeed talking about classified information. The reporters are scribbling down their notes. Can you imagine what a reporter's notebook looks like? And the notebooks include direct quotes that go into newspapers. And believe me, they're not always verbatim.
So Scooter Libby's defense may be that his recollection of events is simply very different than the one that the prosecutor laid out today, which I have to admit, if you look at just on the way that he has presented it, does not look good.
Or there is a possibility, and again, this is only speculation, there's a possibility that he said that, if he indeed lied, to protect the vice president. Not because any crime was committed. Politically, because of the implication that there's something odious about, quote, outing this person. And again, as we all know, it was not outing this person. Democrats like to talk about cronyism. Think about the cronyism involved. The vice president wants to check on the CIA reporting he feels was slanted to underestimating the threat. And whom do we choose? We choose a husband of a woman who works in it's like having a corporation that's been audited by for Anderson, have their results checked by a woman who is married to a mid-level auditor. But there is such an odious feeling about this whole thing, aroma attached to it, that Scooter may have felt that removing the vice president as far away from this was a judicious thing to do, in which case this is an honorable man that's going to be in a heap of trouble because of a very honorable motive.
All right. James, how do you read the fact that Karl Rove was not indicted, and though the special counsel says the investigation is continuing. Do you get the sense that he's in fact out of the woods?
It sounds to me like he probably is. I think if after 2 years, if Fitzgerald had found something on Rove, he would have had the case to indict by now. If he needs to indict, he has to go to a new grand jury. So I'm guessing Rove is in the clear.
Yeah, I agree with that, Paul. I think that by and large, the beanball aspect of this story is evaporating. The political side is something Fitzgerald simply refused to talk about. He was asked about it over and over again at that long press conference, and properly so. And he said, my investigation has not revealed anything that I'm willing to talk about. So there is nowhere really for this mountain that's been made out of a molehill to go at this point.
In other words, this is not, when it comes down to in the final analysis, in the indictment, an accusation about a major cover-up that involves several people in the administration.
It's not a cancer
or any
at the heart
kind
of the presidency.
conspiracy.
It's an accusation about the alleged lies of one government official. So where do the Democrats try to take this? And presumably they will. I read the statements today. John Kerry said that it was an example of corruption, that this administration's corruption. Several others talked about Vice President Cheney having a press conference. Let's get it all out on the table. Is that where this is headed?
They're going to try, but I think we're going to try to remind the Democrats the statements that a number of them made last weekend where they said, we trust Comey. Whichever he comes out with, we presumptively believe his bona fides would believe his probity. Well, they should live by their own words. And I think if we overreach the American people,
you know what? If I were they, I would go after them. And the reason I would go after them...
If you were President Bush and
No. If I were the Democrats, I would run right back at the White House. And the reason I would do that is because it looks to me like the White House has a pretty shaky operation running right now. I mean, the Myers nomination, you mentioned the torpedo. Myers was the second torpedo. These two events almost both destroyed the Bush presidency. And there are obvious weaknesses in the White House operation, and I think they really have to be addressed.
Okay, gentlemen, thank you very much. Next subject. Winners and losers, picks and pans, Tony or Tacky, our way of calling attention to the best and the worst of the week. It may be just baseball, and the season is over, but Dan finds bigger themes in the World Series victory of the Chicago White Sox. Dan, Tony or Tacky?
Well, there are all sorts of reasons to give a Tony for this one. I mean, how can you not love it? After 88 years, the White Sox win. And last year it was the Red Sox after almost 100 years. It reminds me of the old song, fairy tales can come true, it can happen to you. And it gives everyone kind of reason to hope. And secondly, I couldn't get over the starting lineup for the White Sox. It sounded like these guys had shown up from the South Side neighborhood just down the street from the stadium. Konerko, Perzynski, Podsednik. I mean, where was Mike Ditka? And finally, every game, although it was 4-zip, every game was a terrific, fabulous competition. And this is really the reason why everyone in this country compulsively watches sports. It brings to mind the old Jim McKay Wide World of Sports saying, it's about the thrill of victory and the agony of defeat. You just got to love it.
I have to say, though, Dan, as a former North Sider and Chicago Cubs fan, I still don't consider it a Chicago World Series victory. Thanks, Dan. Brent Scowcroft, who served as National Security Advisor in the Ford and the first Bush administration, had some harsh criticism for the current Bush policy in Iraq. James?
This is a tacky for Brent Scowcroft, who is described as a foreign policy realist. That is, somebody who believes that America should unsentimentally pursue its own interests and not be distracted by idealistic or humanitarian considerations in foreign policy. In an interview with The New Yorker, he described a conversation he had in 2003 with his successor, now the Secretary of State Condoleezza Rice, in which he spoke disdainfully of the democratization of Iraq and of the rejection of autocratic Arab governments. And he said, we supported these autocratic Arab governments. Quote, we've had 50 years of peace. Here's a partial list of Middle Eastern wars between 1953 and 2003. The Suez War, the Six-Day War, the Yom Kippur War, the Iran-Iraq War, the Gulf War, the two Palestinian intifadas against Israel, the Soviet invasion of Afghanistan, the subsequent civil war, and the U.S.-led War of Liberation, and civil wars in Lebanon, Algeria, Yemen, and Sudan, twice in Sudan, not to mention terrorism and 9/11. 50 years of peace? That doesn't sound very realistic to me.
All right, James, thanks. And finally, back to baseball, kind of. A Houston lawyer is suing Major League Baseball because, she says, the decision to leave the roof open at Minute Maid Park during the World Series in 50-degree weather made some fans sick. John?
Paul, author Philip Howard talks about the death of reason. That's where our legal system is taking us. Well, it's now infecting the national pastime. Now, maybe Commissioner Bud Selig did a mistake by having the roof open, insisting on that, but this is surely insane. And this is in a state, Texas, that has had major tort reform. I have to tell you, if anything proves we need more tort reform, it's this case.
And gotta love open-air stadiums, John. Thanks. That's it for this edition of the Journal Editorial Report. Thank you from all of us. We'll be back next week, and we hope you'll join us
Exclusive corporate funding for the Journal Editorial Report is provided by Shell.
The 60s? Oh, yeah. All we needed was love. A flower could stop a bullet. And one day, all our energy would come from the sun. They thought we were crazy. Maybe we were. But hey, 1 out of 3 is not so bad.
Solar energy is now powering more and more Californian homes. And who provides it? Terry Jester heads up engineering for Shell Solar. The summer of love lives on.
This program is made possible by the Corporation for Public Broadcasting. Visit the Journal Editorial Report online for more on the issues. Explore interactive features and submit your comments at pbs.org.
We are PBS.